We're live.
Hey, welcome, folks. This is House Corrections and Institutions Committee. It is Thursday, March 12th. We're working on H550, and we have draft number 3.1.
For the last time.
Yeah, well,
Good luck.
good luck. Cheer up. We're going to do a line by line through this one, and it's going to take a long time. Yeah, it's going to take a long time, but I think this one is the one.
Well, it's down to 16. It was, the last draft was 17, so we shaved a page off.
But really, this one, we are gonna need to really do a line by line and understand it. Because it's going to be work on the floor. And we're out there as a team. So Hillary, it's all yours. Could identify yourself for the record.
Right, for the record, Hillary Cheddar Ames for the Office of Legislative Counsel. I'll go ahead and share my screen. All right, so we have version 3.1. This version shows in yellow highlights internal edits from version 2.1. So unlike yesterday, you'll get to see directly the changes that were made. They are fewer than the big changes in version 2.1. This does include at least a start on the changes that the committee was considering based on testimony this morning. So that may require further tweaking, but there is at least some language in response to those points in here. So, Chair, my suggestion is that I first go through to note the new changes in this version, and then if there's further line by line of parts or all, we can track that afterwards. So the first change is on page, this is page 4. Page 4, lines 19 through 20. This was a change the committee discussed yesterday to make sure that this principle was expressed in a very broad fashion. So the department shall ensure that all individuals are addressed in a manner consistent with their gender identity.
So I know we have some DOC folks here. And we have the questions. Haley's here for the whole bill, and Jen is here just for the PREA piece. With the auditing piece of the PREA and also the standards. So if you have questions on the broader piece, it's really more towards Haley. I'm putting you on the hot spot, but that's the plan. Okay. Thank you.
Moving forward, the next change is on page 5, lines 15 through 18. The discussion yesterday was to remove this subdivision 4. It's covered by the broad principle in A, and it avoids creating any small questions about applicability. So for some volunteers, this would create some risk. So the committee decided to leave the broad principle in A without this more specific language. On lines 19 through 20 on page 5, because subdivision 4 has been removed, this is now subdivision 4, and the committee discussed adding language about training proportional to the level that staff, contractors, or volunteers are interacting with inmates. So this now reads, the department shall ensure department staff, contractors, and volunteers receive gender responsive training proportional to their level of interaction with inmates. Pause me at any time, otherwise I will just keep moving forward through the changes.
Yeah, we'll do the line by line. That will get questions.
Excellent. On page 6, this is the non-discrimination provision. After some discussion yesterday about how the broad discriminatory reason or legally protected category language might sweep too broadly, including some things that the department in fact considers, the decision was to remove that second subdivision, but make sure that the first subdivision, which is now the only one, and will collapse into B, is expressed in a broad fashion. So the non-discrimination section now reads, the department's decision not to accommodate an individual's search, classification, housing, or programming placement request shall not be based on the anatomy, including the genitalia or other physical characteristics, or diverse gender expression of the individual.
I just have a structured question.
Mhm.
Is that going to be all one sentence instead of looking like a 1 and a 2?
Yes, because you'll see the 1 and 2 in parentheses are stricken. There's a strike through those. A statutory drafting rule is that you do not have only one subdivision. So if there's so this will all be one sentence as subdivision B. Now that there isn't 2 subdivisions, it will all be B.
Right, so it doesn't look like that now, but when we do this final version of strike all?
Yes, it will.
Okay.
So this is reflecting internal edits.
Okay.
So it looks like it is on a different line, but the clean version,
Will be.
yes. And I do have a version of that. So
Okay.
if for the line by line, you want to use the new clean version after we've seen the changes, we can also do that. And that might be easier. Yep.
Dokey.
All right, moving forward. This next change is page 6, lines 13 through 19. We're in the searches section. And this is based on some discussion this morning. So this might not capture the committee's intent fully, but this is a start at some of the things the committee was discussing this morning. So as someone on the committee noted this morning, this is from the PREA standards. But the discussion was to make some changes for clarity. So subdivision B would read, the department shall not search or physically examine or request that contractors search or physically examine any individual for the sole purpose of determining the individual's genital status. And it would stop there.
Can I just get your perspective legally on your thoughts of striking that, the rest of that? Because that was my suggestion, and I think I'm okay with it.
So the department, both under the federal standards and under the language of the bill, saying that as a matter of state law, the department needs to follow the standards, it will capture that kind of clarification. So removing that sentence, I think that sentence provides additional clarity about what the department may do, but removing it doesn't, I don't see why it would pose a particular problem in this context.
Because it's a may more than a shall.
Well, what's a good way to think about it? I think
It's
the
not
first
required
sentence,
by
the
standards, is it?
well, I think it's kind of more of an explanation, right? So the standards have, the first sentence is really the prohibition. It's the direction, it's the clear statement of what the department shall not do. And the second sentence is kind of explanation or expansion of if in the course of a broader medical examination, you determine someone's gender, that's fine. If when you are talking with someone, you determine it, that might be how you determine someone's genital status, or if you are reviewing medical records. But I don't think that removing it from or not including it in the bill changes any of the meaning of the first sentence. So I think if the Department of Corrections, in operating under both PREA and this language, if they see a challenge with that direction, then that would be useful to know. But from a kind of statutory drafting perspective, I don't see a problem with removing it.
Thank you.
Is the committee okay with deleting lines 15 through 19?
Yes.
I think it's much clearer than what it was this morning.
Yeah. No, that's great.
Thank you.
Right, moving forward, the next changes are on page 7. We're now in the housing and placement determinations section. This is subsection C. The changes just, yes,
So-
I'll pause it.
Okay, I just have a question on some language that is not highlighted. Do you want us to come back to that later?
We can take it now.
When I was reading this last night, on C, department considers individualized basis, whether the individual's request as to gender of staff, for unlawful search, best support the individual. whether a search designation
Where are you at?
on top of page 7, this is during the search, would best support the individual's health and safety, and whether a search designation would pose risks to safety and security. What is search designation?
That is whether, and this will suggest language we could use instead now that we are using the accommodating or not accommodating framework. It means if the department rejects the request. So if the department says this individual will be searched by staff of this gender, that's a search designation. But I think the clear way we could write that, given how we've made some changes in language elsewhere in the bill, is to say, would best support the individual's health and safety, and whether accommodating the request, the inmate's request, would pose risks to safety or security.
When I read that, I'm like, what is search designation?
Good catch.
At 10 o'clock last night. Or 11 o'clock.
Whatever.
I read it to go to sleep on.
Obviously, it didn't work.
It didn't work. Did not work.
Exactly.
Perfect. So the next draft will reflect that change.
Okay.
So on page 7, this is the next change. This is the classification housing program placement section, subsection C. The department shall make classification and housing placement determinations for transgender, gender diverse, or intersex inmates based on review by the department's multidisciplinary review panels. This was a change we talked about yesterday to clarify that the department has these panels, and there are 2 of them, and that this is not intended to create something different, but just references requiring the department to use these panels that they have and have been using for this purpose. The next change is based on some of the committee's discussion this morning. So the multidisciplinary review panels shall regularly consult with medical personnel, mental health professionals with experience in gender dysphoria or gender affirming care, and personnel who have received training aligned with nationally recognized standards for gender affirming care. I understood some discussion this morning to suggest that, although all of those individuals for some medical conflict reasons may not be present on the panel, that the way they could be brought into decision-making where needed and useful, there would be more of a consultation requirement than a representation on the panel requirement. The next change is on page 8. This is still in the housing section, housing and programming placement. In subdivision 1, this is where yesterday we had the 2 alternatives, and we talked about our combo platter number 1 of making sure we mentioned all of these things. So subdivision 1 now reads, the department shall give serious consideration to the inmate's classification or housing placement request if the department finds that accommodating the inmate's request would pose an unreasonable risk to safety or security, the inmate's health and safety, or the safety and security of other inmates or staff, the department may decide that it cannot accommodate the request. In reading that out, some of those ands might need to be ors. So
Be what?
Ors.
ors.
Yeah, because and means
Mhm.
Yeah, that's.
and it's inclusive.
It's amazing what strikes me when I'm reading it to myself before committee and what strikes me when I'm reading it aloud. All right.
Well, and are we still there on number 1?
Yes.
So Chair, can we just go? What do we, okay, yeah. So there was some question this morning, and I don't know if you got to that portion. About, and this is probably a DOC question. You know, is there a moment at which you're considering safety, you're considering security, you're considering placement, and it's a problem that you don't know an inmate's genital status? You know, is there a place where that would be determinative, or you need to know and don't, or, you know, how can decisions be made in that absence? And I'm hoping you can help me frame the question more precisely, but has that ever presented an issue, or can you see an area where it would?
I'm
This-
not entirely sure.
This is the part about, and maybe I'm doing it too early in the bill, but I brought it up here because of housing and security.
And this goes back to talking to Dr. Euler here this morning about you shall not conduct an exam sort of in a forensic way to determine genital status. Has that ever presented a problem? And if it's better to bring up later, I don't know, but
I don't think it commonly happens or ever happens in which it would get to that point of determining the housing placement and we wouldn't know their genital status based on searches at intake.
so it's never been the case that that would have been determined if it was something that was someone needed to know or.
Not to my knowledge, I don't know that that's counted previously.
Could you just run that maybe up the flagpole a little bit between now and tomorrow morning,
Yeah.
or not?
Yeah, I'd be happy to do that.
It is some time between now and the end of the day.
The deadline up.
Yeah, because
They're making a decision in the absence of that knowledge, or I'm not sure what the right question is, but you get the nexus,
Yeah,
obviously.
yeah.
So we could get something by late this afternoon, then if it needs some tweaking in language, at least get that to Hillary.
Okay, I think right now we can work off the assumption that the answer is no, but should that change based on conversations with other folks who are on that panel, I will update the committee.
Maybe I didn't understand what you said. I think your phrase was, it wouldn't get that far.
By the
In other
time,
words, a non-accommodation decision wouldn't get that far because,
no, I'm sorry, I don't think that I phrased that.
Okay.
Clearly, by the time that the housing committee is making these determinations, the individual would have likely already been searched at intake and we would be aware of their genital status.
Because the search at intake is not done for medical.
Yeah.
The search of intake is done for security and safety. It is not done for medical,
got it.
because they could be bringing in contraband, they could, you know, whatever, and everyone sort of has a search when they're booked. Whatever your name is,
Yeah.
Sean.
Jen and or Ellie. So is it safe to assume that there is a process when that happens during search, that whoever's during the search has a box to check that says that person is one sex or the other or not? Is that not what they're doing then? Because that seems to me, if you're doing that kind of a search, you would know that at that point. Is that's my
Well, they're
question.
coming in, I'm just trying to.
Well, I know it's not-
No, but they're coming in with documents. They're coming in there with either a law enforcement document or a court document that has their name and address. Does it also indicate what their gender identity is, that document?
I don't know what the document contains off the top of my head, but I can get that answer.
Because they're not coming in there cold turkey with nothing. I mean, they're coming in there with court papers, law enforcement papers. There's identifiable information on that, I'm assuming.
Yeah, it's true, and I think as our staff have spoken to in the past, law enforcement is making their own assumptions based solely on the kind of physical attributes of the individual, and that it's very possible that that's not consistent with either their genitalia or their gender expression, so that form is not a like be all end all.
So then if you go back to the bill in terms of,
Each box.
yeah, page 5, top of page 5, this is gender identification and non-discrimination. During initial intake process, and then as private a setting as possible, department shall ask each individual to specify the following. Is A, B, and C. It's up to the individual to answer that.
Yeah.
So everything that's asked anyway, regardless if you're transgender or not, it's voluntary information that's given out for anyone. And then it goes on to say that an individual is not disciplined for refusing to answer.
No,
And then after, at any time after intake, an individual may inform designated facility staff of their gender identity. And then that facility staff would promptly repeat the process in subdivision 1, which is what, folks? What's in subdivision 1? of this section, of this subsection. Back to the top of page 5, line 1.
During the
Initial intake process.
Then they have to go back to that intake process. That's how you read the language. So even they may not have come forward at initial intake. And maybe a week later, or 3 months later, they decided to come forward, so then the intake process starts over. Specifically for, specifying your gender identity.
Okay.
So that to me would be how it would be resolved. Right?
Yes. Although I think the question that Rep. Minier had was specific to their physical attributes and not their gender expression.
That's correct.
But you do searches,
Yes.
DOC does searches for forensic issues, security issues.
Yes.
WellPath doesn't do any searches.
No, they'll do an examination. But they don't do searches for the purpose of security. That's in
So when you said they do examination, is it just a regular physical examination, like we go in for a physical?
When an individual is brought into a facility, they're, within a certain number of hours, medical staff will do an initial intake. They can speak best to what exactly that intake looks like and walk you through that process, and to the extent that there is a either comprehensive or kind of preliminary examination of the person.
Because this morning, Dr. Eulinger didn't indicate they don't do searches,
No.
forensic searches for sure, but do they do any examinations?
That would be for like medical purposes, like I'm not a doctor, so I'm maybe using terms that are misleading. But as part of the intake process,
And everyone gets that.
yes, that's for everyone, and that's in statute set by you law.
Well, valid.
Yes, really. Unprepared to listen.
But I don't wanna do that on YouTube. It's pretty. Yeah, I got some questions. I mean, I've got something you could ask. I just don't wanna say it on YouTube.
I know we've testified to this in the past in terms of what that looks like. We also have a graphic on our website that kind of explains what services that medical will provide in the first few days that they're with us. I'm happy to send that to the committee.
Okay.
Right?
It's just, I'm 52. Physicals were different when I was a kid, and I think I was suffering under that false impression. I have a different physical now. It does not involve turning my head and coughing. So, I mean, that's what we're talking about. So that is not something that WellPath does, as far as I can tell. I mean, unless there were some reason to suspect that the person used that for their health.
Very different now. It's not as invasive as it used to be.
Knowing that the committee wants to hear from a couple other witnesses
sure.
after this walkthrough, no, all good. And if there's more to discuss, I don't have to move forward, but seeing no other questions. The next change, so we are back on page 8. This is lines 15 through 18. The discussion yesterday was that this was not necessary added language, that having the language that remains on 14 and 15, the department shall base its classification and housing placement determinations on reliable objective evidence, that captured the instruction well, and the second sentence was not necessary. On line 21, so this is subsection E. Again, this was an edit the committee discussed yesterday, that just for kind of clarity and simplicity, requiring that the department document in writing a specific reason the department is unable to accommodate the inmate's classification or housing placement request, captured the necessary substantive content there. So we removed some of the other language. Next edit, this is page 9 on line 4. This was another edit discussed yesterday. For clarity, this section is covering placement at facilities outside the state. So it says that the department shall consider on an individualized basis whether placement at a facility outside the state would best support a transgender, gender diverse, or intersex inmates' health and safety, and whether the placement would pose risks to safety or security. Still on page 9, this is,
So you going to line 7? I got a question on line 7.
we can pause for a question on line 7.
So we took out contracted facility and just use facility outside the state. On line 7, the department shall coordinate with any contracted facility.
Any facility outside the state.
We're not contracting anymore.
Give me 2 more years as ledge counsel.
No, that's
Asked all these
fine.
things earlier.
No, that's fine. That's
Um,
fine.
But yep, the next draft can make that edit.
Matt, when do you need to go into judiciary? Right now?
It's the third time we've heard that today.
Wow.
There's 100 gun advocates in there.
We're gonna need you.
Oh.
No, I mean, they were supposed to do me at 1 o'clock and I waited around and then I said, I told the committee person that I'm going down the hall and if you need me, come in.
Okay, well, I want to make sure we have time for you, because I know probably won't be too long, but we have time.
One option is after we finish this walkthrough of the changes, before we do the line by line, the committee can hear from the other witnesses that wishes to. So on page 9, lines 15 through 17, this is a PREA regulation. The Vermont statutes elsewhere address segregation housing. The discussion yesterday was that this was not needed in the bill. On lines 18 through 20 and running onto page 10, lines 1 through 2. Let me zoom out so we can capture all of this in one screen. The discussion here yesterday was whether this first subdivision was adding anything compared to the second, and the decision was that the second subdivision is really where the substance was. So removing that first kind of general subdivision, and what remains will just be a new subsection H. So this is page 10, line 3. The department shall give a transgender, gender diverse, or intersex inmate's perception of health and safety serious consideration in making bed assignment, placement, and programming decisions, including 1, housing the inmate with another inmate to best support safety and security, and 2, if there is an articulable risk to the inmate, removing the risk where possible or otherwise alleviating the risk. The next changes are at the end of the draft. I'll pause on page 13 and just note that on line 4, we still need from the Department of Corrections the date that they submit their federal report so that we can align this requirement with that as a temporal matter, in addition to specifying that the substance should be the same.
Do we have?
Yeah. So for the report that you're.
Jen, could you just identify
Oh, I'm
yourself?
sorry, Jennifer Spratley, Vision Rate Elimination Act and Constituent Services Unit Director for the department. The report that you're asking for, are you looking for the survey on sexual victimization that we submit with our annual data of sexual abuse and sexual harassment incidents? So I would love to give you a date, but it is based on when we get it from the Bureau of Justice and Statistics and the Census Bureau. So it's not the same time every year. We typically get it, this year we got it in January. And we've gotten it in May, we've gotten it in March. And so it sort of fluctuates. The last time the date changed because of the executive order changes and they had to modify the survey itself. So it is referenced in the standards. So if we want to say that we'd submit it by the deadline that the Census Bureau requires, I don't know if that is language that you would feel comfortable using.
One option is to say annually. If the data is shifting, the statute can say, starting in 2027.
Yep.
And maybe our statutory language needs to tweak that a little bit, but starting in 2027, the Commissioner of Corrections shall annually submit a report.
And it's always a year behind, obviously, because of the way it works.
So the report that we're asking is the same report that you need to submit to the authorities, to the feds pursuant to PRIA.
It's one of the annual data requirements in PRIA.
Because our language that we've written right here, lines 7, 8, 9, is that the report that we get would provide the same information that the Department of Corrections reports to the feds pursuant to PRIA 34 USC 3031-3039.
So PRIA requires that we do so when they wrote it, it wasn't called the Survey on Sexual Victimization yet, because they had just said, BJS, you have to track it. So that is the mechanism that is required in the standards, is the Survey on Sexual Victimization. We also are required within the standards to do an annual report within the department itself of a comparison of incidents, so that we're evaluating incidents and harm that's occurred, looking at problem locations, problem within the facility itself, so that we can mitigate any potential additional risk if we find any. So that is also an annual report that's required within the standards.
I think it might be pertinent to include in statute which of those two things, if not.
If not
I
both,
would say both.
I would say both, because we really need to know.
All. Or it's required.
Annual reports.
And it's required that those are on our website, which they are. And so there's no identifiables that are connected to any of that information. So it's general review and information for incidents. And I point that out because, and Alice, if you remember from a few years ago with testimony, because they're not the same timeframes, the data ends up being different. And so it's important when folks look at it, the numbers aren't going to be the same because it's always fluid.
It's delayed.
Yeah, and we may have a case where we submitted our annual report in January, and then if the Survey on Sexual Victimization didn't ask, let's say we didn't have to submit it until March, we may have learned of additional incidents that were within that time period that now have been added. So when we reported on it earlier, we said that now we have 13. And so then people say, what do you mean you have more cases? Nope. Or an investigation might have concluded and the outcome is different. And so the numbers are different.
So I think we want all those reports.
Great. So the new subdivision B will say something very close to, starting in 2027, the Commissioner of Corrections shall annually submit a report to the House Committee on Corrections and Institutions and the Senate Committee on Institutions that provides all information that the department reports to federal authorities pursuant to PRIA.
Perfect.
But that second report, do you also provide that to?
So the standards require that we have it, so the auditor reviews it from the website and ensures that it's on the website.
But
So
you
they
don't,
vet the report.
but do you actually submit it to the feds, or you just put it on your website so it's available?
So we put it on the website, because I'm not auditor, I don't know if the auditor has to then download that and attach it within their documents form. We will typically put it in what's called the system that we use to upload the audit information. We'll put it in there just because we want to be transparent. So we put the report and we put the link. So and we have it. It's a report we do, so it wouldn't be problematic. Anybody gets it.
I just want to make sure we encompass this other report that goes into more minutia in terms of what's happening per facility.
And then this was my only clarification, the third report would then be the actual audit reports. So
There's 3
you want
reports.
those.
We don't want the audit reports, do we? I wouldn't think we'd want the audit report.
Yes, they're also on the website. And again, PRIA requires you audit a third of your facilities each year. So 2 of our facilities get audited every year. And it's several pages, which is not to say you shouldn't have it, it's just, it's quite thorough. And goes through all of the components. And again, it's on the website, so
I would do the two, and then they're available.
The audit would be, we know it's a.
And my suggestion for clarity is to, instead of, I think when we were considering this language, it was not clear that there were 3 different reports, and that you might only want some of them. So my suggestion is that we identify by subject the 2 reports that this indicates. So it would be something like, shall submit to the House Committee on Corrections and Institutions and the Senate Committee on Institutions, the sexual victimization survey. Was that the first one?
survey on sexual victimization, yes.
And what's the best way without capitalization, to identify the second?
I was
report?
actually
Okay.
pulling up the standards to see what standard it was. So only for transparency for this conversation, in the standards themselves, it's called the Survey on Sexual Violence because that was the old term, but it's been updated. So in case, because that's in standard 11587. And then within one option is you could, again, you guys determine how you write bills. It's prescribed in standard 11587, and it refers to the annual reporting data, which is incident based, and the survey on sexual victimization. So you could say that we would do that,
Okay,
if that would make it easier.
Yeah, so.
certainly would be clear.
Yeah, so when you've drafted this.
Yep.
Just double check with Jen
Perfect.
And I can,
and vice
as I
versa.
said before, I can send you the language from this standard.
Great. Thank you so much.
Make sure we have time for that.
Yes, so the next draft will reflect language specifying those 2 reports. Moving forward, the next change, this is page 15. In section 11, this is the report back about any changes to the PREA standards or reporting requirements. This was so that, given that the bill in section 6 requires adopting the standards in effect as of January 1st, 2024. And similarly is hinged on each year the reporting required to be submitted to the federal government. This is a way to build in 2 years, a report back about whether any of that has changed, so that there is an intent to, so if there has been a change to the reporting requirements, there would be a chance to amend the reporting requirements in state statute, or if there were any changes to the standards, it would be a chance to make sure that there is alignment. So on or before December 15th, 2027, the Department of Corrections shall submit a report to the House Committee on Corrections and Institutions and the Senate Committee on Institutions. The report shall identify any changes to the standards or reporting requirements under PREA. As may be amended means under PREA if it is changed, so it tracks going forward. Section 12 is a new section after testimony this morning. What I understand, the committee wanted a placeholder for some of the medical care related language. So section 12, gender affirming care. On or before December 1st, 2026, the Joint Legislative Justice Oversight Committee shall review current practices related to gender affirming care in correctional settings and submit a report to the House Committee on Corrections and Institutions and the Senate Committee on Institutions. The report shall include recommended statutory language.
I would recommend putting October 15th.
Okay,
December is too late in case there needs to be recommendations for statutory language. But it is placeholder language.
Okay.
Just in case this survives a little bit, it's better to have an earlier date.
perfect. Any other questions about the changes? It sounds like I will come back for further line by line discussion, but I'll pause here so that the committee can hear from our other witnesses.
That sounds great. Then we can start our line by line after that. Little by little. Thank you, Hillary. So let's put Matt up on the hot seat. I was just curious to reach out to the Prisoner's Rights Office, which is within the Defender General's office. And just want to cover our basis terms of some of the language around the PREA and some of the maybe other language around the bill. I know that this has caught the Defender General off guard. I know you do have a lot of work. Maybe.
Well, you know, a day before crossover, that's plenty of time,
Well, I got you out of that room, right?
temporarily.
I wonder, because the Prisoner's Rights Office is the first time that some of the members here heard that term or even knew it existed. I wonder,
Okay,
I wonder if you just gave a very broad, high-level review of what the office does, and then how you might resolve some complaints that may be coming in, if any complaints come in terms of PREA violations or possible issues maybe around gender equity and within our correctional facilities, if the Prisoner's Rights Office is running into any cases or anything. I just wanted to touch base on that level. So if you could just identify yourself.
sure. Like the chair said, I'm Matt Valerio, Defender General. The Prisoners' Rights Office was established very soon after the creation of the Defender General's Office, which is obviously our state public defense way we call it, state public defense services. And it was in the early 70s in response to the Attica riots. And some states took it on themselves to say, we need people outside of the agency, Human Services or Department of Corrections, keeping an eye on the Department of Corrections and the inmates and people who are in the custody of the Commissioner of Corrections. And so by statute, the Defender General's Office is charged with representing anybody who is in the custody of the Commissioner of Corrections, no matter what their status is, and actually irrespective of means. So we are in the public defense system, we are primary public defense system. There's a means test to determine whether you get a public defender, which the way it turns out, almost everybody qualifies. Oddly enough, poor people end up in the criminal justice system, go figure. But we get everybody who's in the custody of the Commissioner of Corrections, whether they're on probation or furlough or parole or any other status that might be allowed by statute. And of course, the people who are incarcerated. As part of that, the duties of the office are to represent those clients relative to issues regarding conditions of confinement and also anybody who seeks to be released from jail. So sometimes they'll say, you know, I'm being wrongfully held or detained because the Department of Corrections calculated my sentence wrong. And we do some amount of like sentence calculation work. It used to be about a third of what we did was that, and there used to be huge problems with sentence comps. You know, during my tenure, it's been a long time, so I guess a lot could happen. Nevertheless, one of the big issues we deal with regarding conditions of confinement is medical care. It's one of the primary things that we deal with. The department struggles with its medical providers, and we struggle with the department's medical providers. It's been a conundrum for decades and continues to be. We also deal with, status issues, and we deal with all of these gender identity, anything that arises out of like gender identity and the like. We deal with those issues. We deal with pretty much anything that goes on inside a correctional facility that impacts our clients. We represent those clients, and there are various ways we can affect the change that we might want to get for a particular client and sometimes for a group of clients. Filing lawsuits is what lawyers do, and that's one of the ways we do it. One of the things I try to do, especially on the big issues, is to work with the commissioners to resolve issues before we get to lawsuits. There's many issues where there's nothing that we can do, even individually as Defender General and as the commissioner, that's going to prevent that lawsuit. When I was very first Defender General, the relationship between the Prisoners' Rights Office and then Commissioner Gorchik under Howard Dean, who was the first guy who appointed me, believe it or not, way back then, was very bad. And then General Counsel had the opinion that the Defender General and the Corrections Commissioner were not allowed to speak to each other directly without counsel present. And I asked for a meeting because didn't know any better, and met with the Corrections Commissioner, and there was kind of a big blow up, and he threw General Counsel out of the room. And he and I resolved 7 lawsuits in about an hour and a half that had been pending for years between the two offices, because we were able to sit and talk to each other. Since that time, that is generally how things have gone. I have had regular contact with the commissioners of corrections, and there's been a whole bunch of them since 2001. Gorchik was there for he was there the entire time that Howard Dean was governor, so 11 and a half years, I think. But that we haven't had people like that since then. We've had lots of people. And I've gotten along with all of them, probably as you might expect. I try to do that. But there are some more than others. Lots of issues have come up. What you're dealing with here is kind of a very discrete issue. At least the title of the bill, the gender identity issues and the like are more discrete. But all of these issues that are within the bill are something that are within my knowledge, and within clearly the specifics are within the knowledge of the Prisoners' Rights Office. When I first was DG, we had 2 people, 2 lawyers, 1 investigator, and 1 secretary in the Prisoners' Rights Office. And then there were 7 suicides in 18 months in the department, ranging from the end of the Dean administration to the beginning of the Douglas administration. And a commission was convened, created a report, the Marks McLaughlin report. For some of you old timers, maybe there's only one of us here, me and you. I said, yeah, you were here too, yeah, during that time.
You were around, yeah.
Well, alive. But in any event, different times, different folks. But that one of the things that happened there is they doubled the size of the Prisoners' Rights Office. So now we have 4 lawyers and 2 investigators, sometimes 3, but we still have 1 admin person, which is not. Sometime during the Shumlin administration, we had a rescission, and they took a position from us during that rescission. And that position ended up coming out of the Prisoners' Rights Office based on kind of seniority. And so we never got that position back. But that's where we are now. And the prisoners' rights attorneys are unbelievably swamped, as the Department of Corrections is unbelievably swamped. And they have extraordinary difficulty triaging and keeping up with the various complaints and issues that come up. I would say that in the event that I say doubled the size of the Prisoners' Rights Office, it still wouldn't be enough to handle the complaints that come in. And it also, to be honest, is not a particularly attractive constituency. And as a result, it doesn't get, the financial backing that it perhaps could. I also, my opinion is I have to focus on like the primary public defense function. Preliminarily, at least. When I'm trying to advocate for resources and that sort of thing. So, I mean, one of the things I've recently done is taken the portion of caseload that we used to do in prisoners' rights and put it into what I now call the post-adjudication division, which is basically the appellate division plus post-conviction relief cases, which is a whole other issue. So now the prisoners' rights office is not 100%, but 90+% focusing on conditions of confinement and release issues. Those Rule 74 and 75 issues that we've been talking about for furlough revocations, and we've always been doing the parole stuff. And then the medical is a huge issue. I don't know how to solve that issue.
So Matt,
You're specific.
yeah, I mean,
Tell me.
we've got some medical, but we've got housing, we've got placement of housing, search, and then, of course, the PREA. Are you seeing cases coming in at all
All the time.
pertaining to some of this and
All the
gender
time.
equity?
Yes.
Has that increased over the years?
Waxes and wanes with the size of the population.
Yeah.
And the statuses that people are under when they're, if they're furlough, if they are, the issues and rights are different when they're furlough and when they're paroled. And of course on probation. And I can talk about very specific things, like if you want to talk about people who are, like the trans inmate population, for example. I had a meeting for a couple of hours yesterday in anticipation of trying to talk to you with some level of specificity. And those who've been in prisoners' rights for a little bit longer have advised that at any given time, we're dealing with a dozen or so people in the facility who are dealing with kind of the transition issues. There are a lot more that have the gender identity concerns that are not like dealing with like the gender reassignment, medical issues, and the like. But that is it's a relative to the whole, it's a small population, but it's also kind of growing. And we see more. And so I asked some questions and did some research. And one of the things that it didn't surprise me ultimately, but it's people who kind of fit in that category, the LGBTQ plus people tend to have significantly more statistically interaction with law enforcement and end up statistically in jail and in the criminal justice system at a higher rate than the general population. And so it doesn't surprise me that that is growing and that it is so as our population waxes and wanes, whether it's in detention is the biggest growth area, although lately our sentenced population is also growing. It kind of waxes and wanes with us. We just don't have a huge population relative to other corrections places, but so the difference of 100 people makes a huge percentage difference in our population, but we're talking about 100 people. Now if you're one of the 100, you don't think it's so cool, but it's one of those things that it's going to be kind of inherent in the demographic that you're going to see this because of what you see with interactions with law enforcement, interactions with the justice system, and then ultimately as it filters down to those who end up being incarcerated. They clearly have, and I know I haven't been able to listen to really anybody else's testimony on on this or ledge council, except for what I just kind of was overhearing today. But I'm sure you've heard that they have very different needs and different concerns and dangers and the like than other concerns that involve PREA issues. But theirs are unique and not easy. They're not easy anywhere, and that translates into facilities as well. The attitudes of people relative to this population that you see in the general public that aren't always positive or welcoming or inviting translate to the people who work in correctional facilities as well. They're the same people who are in the community. And, some adapt, some don't. It's a struggle whether you're a corrections officer or whether you're working at McDonald's. So it's one of those things, What do you want me to tell you about? Because if you have I actually have a lot of information, believe it or not. I could probably talk for much longer than you want me to.
I think it's just an opportunity for the committee members to ask questions to see.
Your bill is about trying to incorporate PREA into state law so that when the feds basically gut it, which is going to happen under this, come on, let's be real, right? Yeah, whether it's defunding it or you're not going to be getting any rights from the federal level are not going to be looked favorably upon for this population. And so if the states want to do something, they're going to do it locally, which may cause other issues with this current administration, as creates us, we are already a target for a whole bunch of different ways. I look for, there are times when I look for federal money, that kind of thing where, 2 months before Vermont gets declared a sanctuary state, and then the Defender General's office, you may not know this, is charged with representing people in immigration matters that arise out of like all of the cases that we do. This was based on the Padilla versus Kentucky case. But it was the fact that we codified that and placed the burden in the Defender General's office kind of made us a bit of a target for that issue. And so we have to be very sensitive to how we approach these things. It doesn't mean it's unapproachable, but it is, that's just the immigration side. Well, now, prisoners' rights also deals with these issues involving gender identity and the like in the prisons. And we become, again, now we're a big glowing target. I don't know. The only kind of good thing is that we really don't get any, we don't get any federal money anyway, because we're defenders and nobody gives us money from the federal level.
We have a question here, Troy.
Yeah, in addition to codifying PREA at the state level, let me give you just a little more about the genesis of this bill. And it started when a formerly incarcerated trans-identified woman reached out to me saying, I want to talk to you about what it was like to be a trans woman in the Department of Corrections custody.
Yeah.
She spent most of her time out of state, so in men's facilities, all Kentucky, Michigan, Pennsylvania, and recently Mississippi. Talked a lot about her experiences. She started her transition somewhere between Michigan and Pennsylvania. Was able to talk very eloquently about how different that experience was in Pennsylvania as compared to Mississippi, and the harm caused to her because she's a trans woman in a men's facility, especially in Mississippi. And wanted to talk to me about how do we do this better in Vermont. She's released. And when she came back, year and a half prior to her release, she was at CRCF. So she also talked about what it was like to be at CRCF as a trans woman, but also seeing how that identity may have been maliciously used or to get into CRCF by people who maybe should not be there. So this bill tries to thread that needle, to put in place, put in statute parameters for the Department of Corrections for how we're going to treat trans-identified people. That has broadened now to the broader gender diverse, intersex, transgender, but also give the department some discretion for saying it might not be appropriate for, despite the fact that you identify or are now identifying, to move you into, in this case, CRCF immediately. Let's do some more deliberate sort of work on that. That's why we're here.
That case you're describing is not the only one.
Right. So,
Yes.
yeah.
I mean, we talked yesterday. I'm not going to talk about specific people.
Sure.
I actually have like some facts about some cases, but change the names to protect the confidentiality of the people. But prisons are not designed to deal with this stuff.
Right.
That's the bottom line. And I asked, we've advocated on behalf of people to move between the Chittenden facility and one of the male facilities. We've advocated that people go from one place to the other, and once they got where they were, things got worse, not better, and then they wanted to go back. And it's not because the person's being wishy-washy, it's because they don't know what's going to happen.
Yeah.
And they don't know, some of it is the attitudes of corrections officers. Some of it is attitudes of particular people. Some of it is attitudes of the inmates they're with. It is, and I asked my two senior people yesterday, I said, so what do you do? Like, I mean, I'm not an expert in this particular area. And they said, they wanted me to tell you this specifically. You should have somebody come in, like, who has knowledge of national, I have a lot of empathy for what the Department of Corrections has to go through in addressing all of the issues that they have to address. It's not easy. But you should get somebody who is a nationally recognized expert on these gender identity and transition issues to come in here and talk to you about what best practices are in housing and addressing the needs of this population. Because I just asked, I'm always thinking and never sleeping. And I asked my people, I said, well, do we need a separate facility just for the trans population? Like, because they don't seem to fit in a women's facility and they don't seem to fit in a men's facility. And I don't care which place you put them, they're going to have problems. And they're like, well, that's for sure. And they had, talked to me about a few cases. And I said, and is that in what ends up happening I was told that what ends up happening in cases, they often end up getting isolated, segregated, so that they don't, to keep them safe, they end up effectively getting punished by being segregated, which only causes kind of damage. They end up losing their ability to do jobs. They end up losing their ability to, participate in particular programs and things like that, because they're being segregated so they can be safe. And don't discount the fact that the segregation sometimes, I believe, it's not just to be safe, it's to be retaliated against. My opinion, and the opinion of people in prisoners' rights as well. What the truth is, I don't know. There's probably a combination of both, because this can get annoying. Like when you're trying to run a facility for males and you have trans female who is not going to the Chittenden facility and they're put in a male facility, and what do? And you can't give them a roommate, or because the roommate is going to be male and they're identifying as female and perhaps have already transitioned or partially transitioned. It's not easy. So I just started brainstorming, what if we had a different place to put them? There's not that many. There's 12, there's 15, whatever it is. Yeah, and then there's a whole other group that's kind of on the way. And then there are the people who are questioning and don't know what they're doing. And so it's not easy to respond to. And I'm not an expert. So they're like, you should really bring in somebody to talk to who is an expert on this stuff. And in an ideal world, what would you do? Now, we might not be able to ever get to the ideal world of how to address this population. We might not be able to fund it or logistics or staff it or whatever it is. But at least you'd have somebody talking to you who really could speak from as an expert on the subject, because the challenges are so unique. And the population, when you're dealing with a dozen, people on and off over, they said 7 years, a dozen at any given time.
That goes through your office,
No, that that we're aware of.
that you're aware of.
We tend to be aware of them. I mean, that's not the hard part. But it's kind of a consistent dozen. It's not the same 12,
Right.
but it's always somewhere around there. They say 10 to 15. And depending upon how, it depends on who the medical contractor is. There are complaints about, go figure, there's complaints about WellPath. And their amenability to dealing with these medical needs. And, there's a complaint recently that they've set up there's some people who have been approved for gender assignment surgery 18 months ago. And WellPath created a committee now to review the decision that was already decided 18 months ago. It's going to end up in litigation at some point. And that's not a DOC thing, that's a WellPath thing. Now, WellPath is the contractor, but, there's a medical issue involved here. And so, it's like you fighting with your insurance company over, should I get this mole removed because it might develop into cancer, or is it just me being vain and I want it off my stupid face, right? It's much more severe than that, but you argue over those things, try arguing over these things. And that's what you're dealing with the medical contractor. Relative to PREA, if you have more questions about
I got a text
gender.
from House Judiciary. They are taking a break and they're waiting for you.
Okay, do you want me to go and come back?
Yes. Oh.
If you're willing
Or do
to.
you want me to just go?
I know.
I think this is really important.
So helpful.
I don't know, how long would you be over next door?
God, I hope not long.
Tell me you gotta come back here.
Want us to come knock on the door and bring you back.
These gun bills.
I think it's really important to hear what.
I do have more to say. So I'm happy to come back.
Oh, yeah.
They've been trying to get me in on this gun thing they only started it yesterday, which by the way is another good move 2 days before crossover. To bring up a gun bill, because nobody wants to talk about that. As Dick Sears used to say, it's a simple little bill.
I know. They already had a plan.
There's only 1,000 people in a line waiting outside the door who want to talk about it, but so it'd probably be good if I go take care of that
Go take
and
it.
then come back.
5 minutes, 10?
What can we have for you when you come back?
I literally hope it's 15, 20 minutes tops. I
Thank you.
I know I have to do it.
And you're looking.
That's fiscal you were talking about?
Yeah.
Same thing.
All right.
Should we go knock on the door in 20 minutes to get?
Yeah, I
you?
can text Karen Dolan and say we need them back.
Yes.
Thank you, Matt.
I'll be back. Thank you.
I appreciate it.
Mark through there, can I ask you a question?
One of a can of worms and a can
It's pretty bad.
of worms. So while we've got time, let's start our line by line, because that will help us out tomorrow. Great deal. So Hillary, you don't need to, unless you want to get in the hot seat.
I'm happy to sit here.
So we are on draft. Make sure I got the right draft.
3.1.
3.1. So please start reading on page 1 and let's go through A and B first. The C is on, let's go through section 1, which is the intent. This does not show up in the green books. Okay. The folks okay?
That's well done.
And C.
It's well done.
Hmm?
It's well
Yeah.
done.
Yeah, it's the higher
And
risk.
see.
It's okay. I do too, I agree.
So let's go into the next section, which is section 2. Well, read C real quick, doing section 2. Because it's a-
Okay.
So section 2 lays out definitions, and this is just within Title 28, which these definitions are just used here in corrections. And there will be a total, if we add all of these definitions, there will be a total of about 18 terms that will be defined in this section. General, so we're adding a few. So let's. And I do have a question, Hillary, in terms of gender identity has the same meaning as 1 VSA 144. So what does that mean? I mean, what does that definition in 1 VSA 144 say? What I'm. Yeah, I'm just curious. Let people start reading a little bit.
Yep, in 1 VSA 144, the term gender identity means an individual's actual or perceived gender identity or gender-related characteristics intrinsically related to an individual's gender or gender identity, regardless of the individual's assigned sex at birth. Was added in 2007.
2007? 2007.
Surprising, yeah.
That's
Yeah.
impressive.
That is decent.
Line 18, definition 9. Page 2.
Yeah.
Inmate means any person, not a child. What's the definition of a child? Is that?
It's
is that
existing
strict age
law.
cutoff?
But I can do that.
That's,
And it's meant to exclude juveniles, but I can check how and where child is defined, because I suspect it is, if this definition is structured that way.
Hillary, I just want to go back to number 5.
She's looking something up.
yeah, Will.
You can
Yeah,
add,
sorry. No. Yeah, that- Yeah.
Karen Dolan just texted me with, thanks, with a big exclamation.
There you go.
We want it back.
Want 'em back
We
in
want
10
'em back.
minutes.
And
Uh,
Page 3, line 13 is for Troy, which it references work group.
Yeah, right, well, hang on.
Still.
It's still on page 2 here.
Well, I thought we were just working section 2.
Well, you can work through, but Hillary's working on something.
Yeah.
And anything that's not underlined is a
Current law.
definition, current law that we're not changing. But because this tries to maintain the alphabetical order of the definition section, it's renumbering some of those.
So you're still looking for definition of child?
Yes.
If that's gonna be a big hangup, you can
Yeah, but
put that in the parking lot.
we should know because different pieces of legislation have adults or children listed as different.
Which is why I asked,
Right, that's what I'm saying, so it needs.
is it a 20-year-old? Is it a, what is this?
No, I don't get it.
Sure, that's not what it would be.
I wouldn't think so,
But
I don't-
it's,
but I don't know
but
that.
it's good to know.
So Karen Dolan says, I said to him, and we want him back. And she says to me, perfect, that will help us keep him short and sweet.
So the answer to that question is earlier in the same section, so there are those 3 asterisks at the beginning, and it starts at subdivision 5. So there's 1 through 4 that the bill doesn't repeat because it's not changing the numbering or anything else. We have File is number 1. The child means any person charged with having committed a delinquent act as defined in 33 VSA 5102, or adjudicated a delinquent and committed to the custody of the commissioner, or charged with any person charged with being or adjudicated unmanageable as defined by 33 VSA 5102, 3, C, and D, and committed to the custody of the commissioner for felonies and subsequently transferred to the custody of the commissioner.
So I hope that was updated when we have done the raise the age and youthful offender. I hope.
I can check.
I don't want us to go into
That
that
is one of the
Yeah.
challenges, is that definitions are not always
updated.
If it wasn't, then it could be a 19-year-old. We're talking about.
Well, we can hold 19-year-old, depending if it's a listed, a big 13.
If it's not listed,
So for the bill's purposes, the identification, non-discrimination, and search sections will apply to an individual. But the housing section uses the word inmate. So if there's a concern about whether inmate properly captures everyone it's intended to, it would be for the housing section.
You're saying it could be any person, any age,
Individual identity.
individual.
Oh, welcome to all the corrections. Individual.
Because that could be any,
So we use the term,
it could be
No, it's
any
table
age.
20. Yeah, in this email.
we use the term an individual, because it sort of encompasses sentence, detainees, it's kind of more of a catch-all. I don't want to go down this road at this point. I think it's
Either
too,
of you.
it's just a little, that could raise a little flag just in general.
yeah, I wasn't looking to do a line by line. Somebody suggested.
Who suggested?
But that is a concern.
So if there's a problem with the definition of inmate, it is true of all of Title 28 at this point. But that's something that we can take a look at, I can take a look at, so that.
Later
at
down the
some
road.
point
Down
we
the
can
road.
address it.
Down the road.
Now.
If there's a challenge with the definition,
Leave
it
it
would be
alone.
broader in scope than
Maybe
this
somebody
bill.
can suggest
What committee? Justice oversight?
oversight.
Well, there's some opportunities there for litigators.
Let's hope not, let's not bring that to light. So Will, you had a question?
Yeah, I had a quick question. Going back to subdivision 5, I just, that culturally diverse identities at the very end.
Mhm.
Maybe I'm just thinking of it wrong, but how does that pertain to gender diverse exactly?
My understanding, and I'll let other folks in the room chime in or correct me, is that some gender identities are named culturally, like within a certain cultural context, a particular name for a gender identity or a way of being gender diverse. So instead of listing all of those terms, that bucket is intended to cover someone who is right, like falls under the umbrella of gender diverse, but may use a word other than non-binary,
Okay,
gender
no,
expansive,
okay.
gender conforming, that's specific to our cultural
But you think
context.
that it's pretty well defined what that would mean
Um,
in our intent, like just right now?
because it's fleshing out gender diverse, I think it
Okay.
is appropriately general in the sense that it's supposed to capture a number of things within the gender diverse umbrella. But because it's clearly under the gender diverse umbrella, it would be interpreted in that context.
Okay, that satisfies me.
Okay.
Good question.
We're to keep moving
Yeah,
on.
keep looking through the
Okay.
definitions. We're on the definitions, doing a line by line.
Okay,
And Kevin, I think you were out of the room when I mentioned this. These definitions pertain to Title 28, so they only pertain to the world of DOC.
Good.
Okay?
And you probably answered why, but why do we want to be unique in DOC? Why don't we, is there a term that is used everywhere else universally, and why are we trying to be special?
We're not trying to be special.
I think it's more that in statutory interpretation, there might be reasons to define terms differently depending on the context. So there are a few definitions that are in Title I that apply unless otherwise specified as a default for the entire VSA to all titles. But otherwise, different titles will have their own definition section where they're saying for purpose of our area, this is what it means. Adopting a term in Title I as applicable to all titles is just a bigger endeavor because you want to look at any time that term is used anywhere in any title. And there might be different opinions about how that term should be used in different titles.
Gotcha.
So I think that's we start small for definitions and a project to adopt a definition applicable to all titles, which is be a slightly bigger project.
I think I understand.
It's how we do legislation across the board. I mean, there'll be definitions in DCF.
How do you use the word love? Filio, agape, whatever, one word. You better define what you're talking about. Yeah, I got it.
Let's keep reading. Through the definition sections.
Wanting us to look at the ones that are not underlined as well, just in case, or,
If you pick something up like Joe picked up child,
yeah.
but
Write my summer to-do list.
Yeah.
If you find something else.
Right, you know, so.
Have one, help things open.
I'll mention.
Pick up.
the definition, no, the definition of inmate, it says not a child, how do you define a child?
But that is what the statute says.
That's.
Right, we know
Yeah.
that, but there is a definition in DOC
Yeah.
that does define child, and then that brought a question up, ooh, is that how it's really used?
Yeah.
So I find it interesting that correctional officer title, definition of correctional officer is also the duties and job classification, including monitoring folks on parole and probation. They're considered correctional officers, but we classify them as P folks for hiring purposes. I found that one interesting.
Only because they're on definitions is the word line 3, outside traditional
What page?
markers,
What
there's a
page are you on?
page 3.
Okay,
Where?
There's the word traditional as opposed to biological.
oh, so intersex describes an individual with a medical condition which the individual's sexual or reproductive anatomy or chromosomal patterns fall outside traditional markers of female male. And you're wondering what word?
Traditional.
I know.
Biological is a better word than
Biological.
traditional.
I think that hits it better for.
Uh-uh.
I don't think she can.
Oh,
Hillary?
So it has a different meaning, right? Like there are some times where we
Oh, it does.
replace a word and it's a different way of saying the same thing. Replacing traditional with biological here would be a different meaning. I guess my understanding of why this medical condition is defined this way is that one of the traditional markers of, use traditional. One way medically that someone could be determined female or male is based on chromosomes. And some intersex individuals have chromosomes that are not what is recognized as male, what is recognized as female. Which is why I'm just not sure that biologically captures the medical condition. Because biologically they have. Anyway, I'm not an expert on this medical condition. I'm happy to look at how other like medical societies define it to see if they use the word biological or suggest that there's another way to say this. But before doing that, I would want to check that before offering to the committee changing it.
I'm not suggesting it, I'm simply questioning it since it's in the definition, and I do understand there's a major difference between traditional and biological.
Maybe in the medical field, that's totally quite different.
Oh.
That was the question.
Absolutely.
Where did you source this definition?
Yes, this is the definition used in DOC's policy.
In DOC's policy, okay.
Yeah, which is the approach taken
Most, yeah.
for the ones that we added.
Okay.
I'm going to check folks should keep reading. I will look at a few of the sources I originally pulled, which are from a more medical place, and just to see if they offer some other ways of saying this for purposes of answering, what work is traditional doing there.
It's, so. When we use the definition with training, biological, because it's really attached to a medical definition, tends to mean the presence of something or not the presence of something. And as we've gotten better with science, when you're talking about like a chromosomal breakdown, that's not necessarily seen as biologic because it's not necessarily an anatomy. And so those traditional markers tend to be more fluid because it's not things you're seeing. So there may be aspects of a person that don't fit within the older definitions. Like we don't use the term hermaphrodite anymore, not because it's discriminatory, because it's just not scientifically accurate. Hermaphrodite means it has to have the presence of both. And what we've since learned is, because we're so good at science, not everybody has both. Some people, they may not have a uterus, but that doesn't mean they have a penis. And so that's why the term, universally, we tend to see the term traditional versus biological, because people tend to think biological means I'm going to see something, and you may not see anything.
So Hillary, I just want to be clear for the definitions, the new definitions that are here have been picked up from DOC policy.
For gender diverse, intersex, and transgender, yes. For gender pronoun and honorific, those were in the bill as introduced. I believe we heard testimony that they are consistent with DOC policy, but I did not draft this bill originally, and so I cannot say that they were taken from the DOC policy. But the ones that have been added that are not defined in statute, like gender identity, were taken from DOC policy.
Is there any other policy that we have listed differently?
Any other
I mean, another,
forgotten agency policy or, I did not look at.
I just want to keep it consistent if with what we're doing.
Right, I think that is one reason to keep this in Title 28, that if we are in Title 28, the agency definitions that will apply to the Department of Corrections from a policy perspective. The subcommittee did consider whether to use some other sources of definitions. There are medical organizations or other, other state definitions. There are options, but the choices we took, I think, from I won't speak for them, but from maybe a practicality standpoint and ability to implement this, that the department definitions that worked in their policy and that those captured what we were trying to capture.
Korea does have a definition, and they use the word definitions as opposed to biological or characteristics. A person whose sexual or reproductive anatomy or chromosomal pattern does not seem to fit typical definitions of male or female. Intersex medical conditions are sometimes referred to as disorders of sex
So
development.
definitions.
So
I missed some of this conversation, definition.
I was asking if there was other definitions of what tradition or biological of other agencies or states or whatever. And it mostly goes from the language of DOC, but you just read the,
what Jen just offered, which is one of the possible sources, is the federal PREA has some definitions in the regulations. There are some definitions in PREA guidance. And so the definition for intersex, which I'm not sure if that's in the regulations or the guidance, we can double check.
It's in the
regulations itself, perfect. Intersex means a person whose sexual or reproductive anatomy or chromosomal pattern does not seem to fit typical definitions of male or female. Intersex medical conditions are sometimes referred to as disorders of sex development. So one option the committee could consider is if typical better captures the tone or the meaning that the committee wants. It could be patterns fall outside typical markers of female or male, at least based on how PREA defines it, which, as we've talked about, PREA is kind of the governing federal law for a lot of these issues. And so how they are using these terms is a useful direction and helps the department be consistent in its obligations or the way it's defining things. So if there's any part of that definition, and I can bring it up on my screen if people want to see it. I was gonna say see it visually, which is repetitive, but anyway, if anyone wants to see it on the screen, I can bring it up. And if there were parts of that definition that the committee preferred or thought were clearer, I think that could be another option.
So I go back to this particular definition as well as gender diverse, intersex, and transgender. They're currently all part of DOC policy. This is how they're defined in DOC policy. And I think it would be really important at this point to track what current DOC policy, their directives. I mean, those are actual directives and policies. I mean, so there isn't any more confusion, that we track what currently DOC has in their directives and policies. Not to add any more confusion.
That was the,
Intent, right?
well, that's where the subcommittee landed as well,
right.
that these two align wherever possible.
Yeah, it's really important to align with current practices within DOC that is.
If there's an intention to change how DOC is doing things or thinking about things, because a different definition would suggest an intent to change. So if that is not present, then that is an advantage to using definitions consistent with departments.
So is the committee okay with the current definition, top of page 3?
Yes, ma'am.
Additional, yes.
Okay, so let's keep going here. So the last definitions on page 4, lines 13, 14, that one again is through the DOC's directives and policies.
And again, slight modification for statute, as we talked about the other day, but this is not verbatim. We generally, when we put definitions in statute, say either the term describes or the term means. So that's one small difference, but that's not substantive.
Anything else on the definitions before we move to section 3? Section 3 deals with gender identification and non-discrimination, which first A deals with the overall, that the DOC would ensure that draft, I want to make sure I'm on the right draft. That all individuals are addressed in a manner consistent with their gender identity. That's the overall overarching statement in terms of how the department addresses folks throughout the system. And then when you go to page 5, the top, this is, 1 is the booking, 2 deals sort of with the booking, and 3 deals with after someone has gone through booking. It could be a couple days later, it could be a year later, it could be 2 years later. That's how this section, I'm thinking, operates.
2 has kind of a double application, like you said, sort of at booking. So if these questions are asked at booking, the individual will not be disciplined under 2. And if the questions are asked later, so 3 says anytime afterwards, the individual can inform staff. If those questions are asked again, then the individual cannot be disciplined for not disclosing complete information at that point too. So anytime these questions are asked, in 1 are asked, whether at booking or later, based on 3, then subdivision 2 says you cannot discipline someone for not answering, giving incomplete information.
So I don't know if number 3 is that clear, because number 1, during the intake process, it's in a private setting if possible, and the booking rooms are not private. Tell you that. Well, no, common area. What, you're talking about my pen? All these, anything that happens in booking, regardless of who the person is, what their sexual identity is, they're voluntary. The answers are voluntary. So just keep that in mind. For anyone coming into booking, you can ask, do you have a driver's license? They don't have to tell you. Are you on medication? They can tell you half of what they're on, not the other half. So it's all voluntary. So just, that's true for anybody going through booking. So number 1 is for folks in booking.
I'm sorry, when isn't it voluntary? We don't, and I'm not trying to be funny, we don't interrogate anybody. Isn't it always voluntary? Is there ever a time where DOC can forcibly get information from someone? I'm trying to understand why you're emphasizing that it's voluntary.
So that everyone knows what the booking process is.
Yep.
And that it is across the board, whatever information the person who's coming in to be booked, whatever information is given to the booking person, it's all voluntary on the person coming in. Just, that's where it works.
Right.
I just want members to know that.
Okay.
That this isn't anything specific for folks with gender identity. This is not specific for them, maybe not volunteering how they identify themselves. It's not a carve out.
But Dr. Uliger said too, it was either last year or this year, that people do come in and they have walls up initially. But then after a few days, they kind of loop back around and touch base with them if they're going to stay there longer, and they do share more with them when they've come down and stuff. So, human nature, you're going to go into a place like that. It's not like you're going to, you're probably scared to death. What?
He said it this morning.
He said that again too. Right?
Yeah.
Yeah.
No, that's not true. I was just trying to
Yeah.
understand the significance of saying. it's
Volunteer,
voluntary.
yeah,
It's always
right,
voluntary.
right,
You- We don't string anybody up and. Well, no, I'm not trying to be funny. I'm trying to
No.
understand.
Right.
what the purpose of, I got you.
Stringing something up, it sounded.
So I do have a question. Number 3. After intake, the individual may inform designated staff of their gender identity, and then you got to repeat the process in subdivision 1. It does not refer to 2, where the person would not be disciplined.
The language of 2 hinges on the language of 1. So the way 2 is drafted, anytime the questions in subdivision 1 are asked, an individual shall not be disciplined for refusing to answer them or giving incomplete information. So even though 3 itself does not say, ask them again, and also 2 applies, 2 itself will apply anytime 1 happens, anytime the questions have been heard. One option, that could make that even clearer is if you swapped the order of 2 and 3. Then you have, it clarifies that 2 is not just at initial intake. But I don't think that's necessary to make that clear, because the language of 2, I think is, from at least a statutory perspective, is clear that anytime the questions in 1 are asked, individual cannot be disciplined for refusing to answer. But putting it after 3 is one way to kind of signal this isn't just initial intake. It's not like subdivision 1 is intake, subdivision 2 is intake at any time, subdivision 3 is at any time. And you could even add at any time. I would do it a little differently, but you could also add language about any time to subdivision 2. So if you wanted to be super clear that 2 applied anytime, you could say something like an individual shall not be disciplined for refusing to answer or for not disclosing complete information in response to the questions pursuant to subdivision 1 of this subsection. I don't like anytime, at any time at the end, but anyway, I could come up with a good place to put at any time in subdivision 2. That would be another way to signal that it always applies. So if the committee likes that clarity, I'm happy to do that on the next draft.
She says it's on subdivision 1, right? Of the subsection,
So it says subdivision 1, which is
Right.
only this.
right?
It's not this. So if they lie, or not lie, but if they refuse to answer
Yeah.
any of this in 1, this then kicks in.
Yep.
Right?
Exactly.
So if they refuse, if they're going through that process in 1, after they've been there a year,
Mhm.
and they refuse to answer, then number 2 kicks in, because number 2 is connected to number 1.
Correct.
Got it?
Oh, yeah.
Awesome.
Oh,
Great.
back in.
Let's just get through number 4 down on page 5, and then we'll go to Matt.
I'm fine keeping it 1, 2, and 3 as is in the same order. I don't think. we
I
need
think
to-
so, once we understand how it
Yeah,
works.
yeah.
Okay, let's go to 4, which is a new 4. And this was a way to address the volunteer section as well as contractors.
Yes.
Proportional to their level of interaction with inmates. So that piece right there, A, 1, 2, 3, and 4 is for gender identification and how you address the person. That's what. Okay, that's the overarching process for DOC. And then at the top of page 6 is your non-discrimination clause.
Right. And we got rid of that funky meaning based on the legally protected
Right.
category. Just left it alone.
Yep, that's gonna be one. complete
And that's just one
sentence.
big sentence or paragraph, whatever.
So you cannot discriminate a person's search, classification, their housing or programming placement based solely on their anatomy
Or other physical characteristics,
or other physical
like a
characteristics.
sweet mustache.
I'm glad I missed that one.
But now that means I get to ask another dumb question.
Uh-huh.
May I?
Uh-oh.
Yeah.
Line-
Uh-oh,
Just 'cause
here we go, we're ready.
Line 8. Give me an example, please.
Line 8.
Line 8 of page 5.
Oh, page 5.
Yeah, page 5, line 8, page 5. What's an example where it's appropriate to discipline someone for refusing to answer?
I mean, within corrections in general?
Yeah, well, yeah, this says we can't discipline them for refusing, so what would be an example where it is appropriate to discipline someone for not giving you an answer?
I could, well.
Yeah, but I don't know if Haley heard this or not.
Yeah,
Sorry, where did
Did you
you?
hear the?
I'm trying to learn, I'm not
Okay.
objecting. Line 5, line 8 on page 5 refers to an individual shall not be disciplined for refusing to answer. I'm asking, what would be an example when it is appropriate to discipline someone for not giving an answer?
About anything or just a specifically?
Anything throughout the correctional.
The opposite.
Oh,
Whatever.
Yeah, like if you're on, I was representing somebody one time and inmate bragged to all his friends that he peed in the guy's iced tea, correctional officer, right?
Huh?
Said, did you pee in the iced tea? I'm not answering you, right? I'm not answering you. What do you do in that case, right? It's,
They do discipline them then?
my recollection was there was some discipline on that. This was so many
Years
years ago,
ago.
yeah. But that would be an example, right?
No,
Yeah.
that's exactly what I'm asking. Okay,
Yeah.
so under a situation like that, refusal is guilty.
Yeah, I mean, like,
Okay.
yeah, he said he had
Got it.
hepatitis and
Thank
he,
you.
yeah.
I'm with you.
more
Thank you.
hepatitis, yeah, it was
Yeah.
more spreading of issues like, yeah,
Big deal.
it's a big deal.
Thank you.
The language that's in the bill is included because that's consistent with what is in PREA standards. But regards to your kind of earlier question of discipline that might extend outside of these circumstances. Lack of answer is not guilty, it's based on a preponderance of evidence,
Right,
Right.
fair enough.
but that's not contemplated in the bills.
And that was helpful. Thank you.
Okay, anything else on the top of page 6 for the non-discrimination piece? We went through that at last yesterday.
Can we backtrack, sorry, to page 5, just identified a slight concern on lines 19 to 21.
Okay,
Around the training that volunteers receive. As they do not currently receive comprehensive gender responsive training in the same way that we don't provide volunteers who are there, for example, for religious services, comprehensive training on mental health services. So this would be something that the department would have to add for volunteers specifically.
I thought we went round and round on this yesterday.
We did, I think it was more so to do with the
Contractors?
no,
The use of gender pronouns and honorific, I think
yeah.
that was more of the discussion was focused on the challenges of applying that to volunteers. Whereas offering training does not necessarily negate the same concerns. But I think Kaylee's flagging that the committee should be aware that if the bill is requiring the department to provide volunteers with gender responsive training, that's not something they currently do. For a consistency across the board for volunteers, it sounds like, or kinds of training provided to volunteers. So if the committee is including this, it would be something the department would need to have.
So are you recommending we should take out volunteers?
I think that would be most appropriate, as it's not something that we currently provide, and this would kind of disproportionately add a section to our volunteer training, whereas we don't provide comparable training for other kind of factors in correctional facilities.
So maybe like, so line 18 with experience in gender dysphoria or gender affirming care, period, kill the rest.
We're on page
You're
On page 5.
Okay,
I was like, what are you reading?
I'm reading the wrong thing.
You're on
That's all right.
page 19, lines 19 to
I
21.
think I can.
I was just looking at the wrong page. I
Okay.
flipped back to the wrong page.
So training, right? Staff and contractors proportional to their level of interaction with inmates. Great. If we want to take volunteers out of there, we're still covered under A. Department shall ensure, well, that's addressing training.
The department shall ensure that all individuals are addressed.
You provide any training to volunteers right now?
See, that's what the discussion was.
That
We
was
just saw everyone providing some kind of a service, even volunteers.
I guess I don't have a quick fix.
That was,
Because I think gender responsive training is important. If there's going to be a group of volunteers that are regularly interacting with Department of Corrections inmates,
they should.
that include gender diverse inmates. There, I don't have a problem with requiring that sort of gender responsive training. But I know where we're going to go with this, right? We're going to get religious volunteers who have sincerely held religious belief that is in conflict with providing gender responsive contact or services to, yeah. I see where I'm sorry, I'm thinking and talking at the same time again, but
Yeah, we're used to it. We all do it. So we went round and round and round on this yesterday and the day before on volunteers, and then we ended up focusing more on contractors. I think that's where the language proportional to their level of
Yeah.
interaction with inmates came up, was more in terms of contractors.
overhead, yeah.
Some had, right. But we never did resolve the issue of volunteers. Volunteers that come into the facility, there's a variety of volunteers. They have to work with a volunteer coordinator that's there at each facility. And they have to be approved. And there's quite a extensive process for them to be approved.
Right, so the volunteer coordinator could be well-trained.
Volunteer coordinator could be trained, but they're part of DOC staff. which-
They're already defined.
Right, so the volunteer coordinator has been trained, according to this, to, gender response, has received gender responsive training. And if we find ourselves in a glitch where a certain volunteer who wants to be a volunteer, right, let's let the volunteer coordinator handle that.
So take out volunteer.
I think we're okay.
Folks?
I think we're okay with
You
that.
having to range? Okay.
And just to add too, we do provide career training for our volunteers.
Good, that
Okay,
confirmed what
then
George
that's,
just said.
then that's,
Oh, sorry.
No, that's good,
No.
that works.
Yeah.
Perfect, so
Perfect.
let's take out volunteer.
But-
Okay,
but
now
what-
what?
Contractors.
That's all right, because we address
Contractors.
contractors to
Yeah,
proportional to their level of interaction with
Yeah.
inmates.
Okay. That's, all right, gotcha.
So I'm looking at the time, I know Matt has come back.
Come back, man.
Welcome back, so let's put you back in the hot seat, because I know you wanted to share some more things, so when we come back to line by line,
yeah.
Section 4.
it will be section 2. I didn't keep you in there very long,
The first thing I want to hear about is that.
mess, huh?
Well, it's really hard, and I've said this before, I've said it to you folks. When you are trying to legislate around a constitutional right.
Yeah.
And I just say, hey, when you start dealing with these direct rights issues, you have to tailor it as narrowly as possible, or you're gonna end up having a problem. Even though, you know, hey, what you want to do might be a great idea, but it might not be constitutional. And so this is what we're going to do if you do that. And then everybody tries to convince me, you know, they're trying to convince me their idea is good. I don't care what it is. I'm like,
Yeah, that's what we love about.
we're
you. Just say it.
we're representing a client who has an interest. And if what you've done has infringed upon some right, or even if it hasn't, and we have a way to resolve the client's problem through litigation, we're going to do it. It's not personal. It's just business. But, you know, I'm not making a judgment.
That's why they enter into plea deals.
I know.
I'm not making a judgment about whether you're right or wrong, whether I like you or don't like you. It's just what we do. You know, what lawyers do.
So it's
And-
possible that sometimes you don't like them.
Like
Frequently.
Oh, yeah. But it's not necessarily.
Understood.
Yeah.
I mean, but something could be a great idea, feel good and just be, but it could be unconstitutional.
And you know, we don't have to love all our clients either. Or their issues, or the result that we're gonna get for them because they're gonna, you know. But it's the job. And
We've
you're either
got
gonna do the job or you're
25
not gonna do the job.
Or-
So if you're not gonna do it, you don't want to do this.
Before, is that what you said, Mary?
It's,
And then what do we? then-
Not allowed.
I don't know what's gonna, I think we're gonna have a long day today.
We were,
Be prepared tomorrow, we're gonna have a long day.
I spent most of the time talking about the gender identity issues and, you know, trans inmate issues, but the PREA issues are significantly more important, much more important, broadly, broader of an issue, and like the federal implications of again, you know, being a state that the feds go one way, we go the other way. You understand that. You and I talked for a minute yesterday because I want to know what the heck you guys were actually talking about.
Give me the riot act.
And, no, I just said, what, were you kidding me 2 days before crossover? We've both been here 100 years, you know.
Literally.
And so one of the things you asked me to talk about, I said, you know, does the Defender General's office get PREA complaints? We don't get PREA complaints. That's not where you complain to make a PREA complaint. People will talk to us about issues that implicate PREA complaints that are then made through the process at the Department of Corrections. Inmates complain to us about the PREA complaint process. They complain to us about the PREA complaint system. They complain to us about what happened to my PREA complaint. So do we get those? All the time, from facilities, all facilities. And we do not investigate PREA complaints, right? We investigate and sometimes litigate the DOC response to PREA complaints.
Mm.
It is something that is inherent in correctional facilities. Not Vermont only, but
What is inherent?
PREA complaints.
Okay.
They're everywhere all the time. They're in Vermont, they're everywhere else. And some are legit and some aren't. And my concern as Defender General and the Prisoners' Rights Office concern regarding PREA complaints is that they are handled expeditiously, appropriately, and that inmates are not disadvantaged by either making or not making complaints. You don't want them to be deterred from making complaints, and you don't want them to be somehow disadvantaged or retaliated against if they do make them. You want to make sure that the process is followed and that the result, whatever it is fair. And is it always? No. Is it this is a hard area, you know, where you've got power dynamics in a correctional facility. But the power dynamics go both ways.
Mhm.
You know, making a PREA complaint gives inmates power. Being a corrections officer also has clear power dynamic. So this is a very complicated area. This isn't so clean cut as that, you know, the inmates are abusing the guards and as a result, there's a PREA complaint. Or that there's a one inmate abusing another inmate and that creates another PREA complaint and another dynamic. Or that somebody's ignoring my complaint or whatever it is. These are very complicated power dynamics that are at work here. The only thing that we can attempt to do is to ensure that the process is good and robust and fair and quick, in my view. DOC, during my tenure, PREA wasn't always as big of a concern. Yeah, like I said, I've been around 25 years. 25 years ago, it was not as big of a concern as it is now. It hasn't been that long. What do you guys have? 4 people who investigate the office that deals with them? There used to be one person who dealt with all PREA complaints for like everywhere. And now there's a few people. I don't know the exact number. I think it's like 4. But there literally used to be like one person. You know, yeah, that's what
We have 3, 3 in my unit. And additionally, the corrections, including me.
So there's
So
your 4.
there's 3, no, there's 3 total. There's
Yeah,
myself.
so,
and
ballpark. But bottom line is, it's not like you got this giant staff of people dealing with all of these PREA complaints. It's a small group of people. That in and of it, and, you know, and it is not, just like we can't handle all the complaints that come to the Prisoners' Rights Office, they can't handle all the PREA complaints that go to the Department of Corrections. I know that. So what do you got to do? You have to triage as best you can, investigate as best you can, and then there are inherently going to be problems as a result of that. I get it, you know? And so we have to also sort of triage and figure out what do we know about this inmate? What do we know about, you know, what are the motivations? What are the power dynamics that person has? It's like I said, this is very complicated stuff. And the only thing I kind of good about you guys, if you guys had 4, we only got 4 too. So we're looking into it. So, you know, I have 2 investigators and looking into it now and you know, they got 3 people or whatever it is. Bottom line is, action does occur when a PREA complaint sets a process in motion that is imperfect. And it doesn't always have the best results. But it also does get good results. Before I was Defender General, I had a law practice for 15 years, more or less. And I used to represent corrections officers who had disciplinary action, some of which involved PREA violations. Or then they're really just talking about like fraternization kind of issues. I don't remember them actually coming up in the context of PREA per se. But so, you know, relationships, for example, between inmates and corrections officers do occur, and will continue to occur. And they would be in violation of, you know, if somebody wanted to make a PREA complaint, they could. And I used to represent those folks, representing the corrections officers in those administrative proceedings. So these were not unknown to me before I ever became Defender General. I just didn't know the context they would arise, or the fact that it had become more important and more visible as the years went by and PREA became more of a priority, over the last period of years. Some inmates have relayed that they believe that the result of their PREA complaint has resulted in retaliation by the department. And some feel that even though it was not dead-on retaliation, the response relative to the complaint disadvantaged them, even though it wasn't a blatant retaliation. It's just the things that had to be done, transferring them, moving them, taking away a job, taking away or not allowing them to do some activity or privilege or whatever it is, to segregate them from the, kind of the investigation or how it responded, or if an officer ended up being suspended or terminated, what was the response of the other officers, knowing that this person had made a complaint. This is where this is very complicated. It is, to me, human nature. And what I say about this, and I've had some number of people come and go from the Prisoners' Rights Office over the last 25 years. Some have been very, very good lawyers, but could not really stomach this work. Those are the ones who want to solve every problem. You can't solve every problem. What we can do, our best to do, is to make sure that the process is all right. And knowing that it's flawed, inherently, that it's under-resourced, we just have to put one foot in front of the other and do the best we can every single day for any individual client. And sometimes we can't even do that. But I think there are things that could be done to make the PREA process more usable and transparent for our clients. I think that what they think they're going to get by making a complaint is not what they get.
Yeah.
And that's not necessarily that what they get is wrong, but that's not what they thought was going to happen. I think that they need to understand better kind of what they know. Well, I'm going to make a PREA complaint. They don't know what happens next. They know Prison Rape Elimination Act. Okay, fine. Well, what does that entail? So they enter into kind of this abyss of what happens until they go through it. And by the way, it's not the same for everyone. And it also is different in every facility. Who you report to also makes a big difference. How you report makes a difference. So I think there's progress that can be made in this area. This is, again, one of those issues where if there was a best practices expert outside of the department and outside of my office who could come educate us on maybe what we should do better or what we could do at all relative to these complaints, we might be better off. Because right now we're just doing the best. All of us are doing the best we can. And so we can get that process in place. How it gets implemented in any individual case and in the field is always going to be a conundrum. As it is, with the differences of any people and, how one law enforcement officer enforces the law is different than how another law enforcement officer enforces the law. And so, and how they interact with people, some people are just jerks and some people are perfectly nice. And they're both trying to do the exact same thing. It just comes off different, And so that all of those things go into this process, but it's such a sensitive area that it, that it bears scrutiny and constant review, and not internally. We have to let people from the outside look at what we're doing and advise us. And then, periodically, not just when like kind of the stuff hits the fan, this is I was talking earlier about like the Marks McLaughlin report. Do you remember the one before that, the Carriger report?
Oh, yeah, I remember that.
You remember and then you remember the one after that, the most like I've been around now for 3 levels of reports on similar activity, and the Downs Rackland Martin report was the next one, right? So they're one after another after another. Well, we shouldn't do it just when we have a crisis or just when we have that's part of our job, is to try to make sure. But, people come and go. I'm around long enough to know about Carriger, Marks McLaughlin, and Downs Rackland Martin. And nobody in my current prisoners' rights office was around for anyone except for one was around for the Downs Rackland one. All the other ones don't know about any of the other stuff. So it's context. And, anything I've learned over time with this context is this kind of this external review of what we do is always a good thing. And, we'll never be able to I don't think we can implement all best practices. We don't have the money, we don't have the people, we don't have just the generalized resources, but it gives us something to aspire to. And that ball, it changes, it moves. And so the more we can periodically look at it, the better. I know that, if I had brought in people from the Prisoners' Rights Office, they might have 10 specific things that they want to do. We're not going to do that before crossover, right? So that might be something for joint justice oversight in the future. It might be something for the other thing they tell me, and this is true, to be honest. They are litigators, they are lawyers, they are not politicians. When lawyers come here to communicate, they talk like lawyers, and it pisses you people off.
I don't understand them.
Well, they communicate differently, and they mean no harm. But that's why they send me, because I communicate more like you want to be communicated to. Bringing in a litigation prisoners' rights office person, I get them, but I cross over both worlds. They don't, and so that's why you get me instead of them.
We appreciate the straight talk.
Oh, I appreciate you making the time, Matt. I hope it's been helpful for the committee to at least get a handle of what's happening with the Prisoners' Rights Office, also how that works in with DOC, back and forth. We scheduled to be on the floor here in about 4 minutes or so. Are there any questions?
I would just say overall that we work, I would not always say collaboratively, but it's not hostily with the Department of Corrections. When we file lawsuits and the like on behalf of clients, they know we're going to do it. They understand it's what we do, and we do. And when they do the stuff that they do in response to those lawsuits, I know that that's what they're doing too. So this is not personal. This is just what we do, fulfilling our roles in government. The tension or lack thereof between the corrections commissioners, people at the very highest levels, has been up and down over the years, but since that first incident with John Gorsuch and his then general counsel, it went from like being really crappy down here to it's kind of like here. Sometimes it's really good, sometimes it's a little bit less. But we're kind of working in this gray area, not like in the gutter down here, which is where it started. So I'm thankful for that. And we always, when there are transitions with commissioners and changes in their general counsel and the like, they all need to be re-educated. I have to kind of talk about some of this stuff because they don't always understand either. I was very, and some people don't like it when I do this, but I will say I was very thankful for the time that I spent working with Nick Demmel. He did as much that I've seen, and I don't even know if people in the department appreciated it as much, but he was a stand-up guy. He was trying to do the right thing and worked very hard to do it. And I know we ruffled some feathers, but it was all with the best of intentions.
Great to hear. I really appreciate those words, Matt. We're gonna have to close, but I want to thank you, Matt. Now, before anybody leaves, we still, for Hillary's schedule, because
Can I leave?
yes, you can leave. I'm talking about the committee members.
Thank you.
I literally had.
Depending how late we go on the floor, if you're worried about tomorrow, tomorrow's our last day. I don't want to be here till 5, 6 o'clock on Friday.
We have to, should we come back?
I would like to come back if possible, at least, we've got to go through the line by line on the searches, classification of housing, and program placement. And then the rest of it is PRIA, which I think we're pretty solid on.
Yeah.
And then report back of PRIA.
Because it would be easier for all of us.
It'd be easier
Get the
for
language
Hillary.
tonight so that Hillary
Yeah.
can work and we're
Even
not
if we have to work
trying to
to
do.
No, nobody wants to be here till late.
No, nobody does. So if we could come back here after the floor, and even if it's 5 o'clock, if we can come back and see if we can get done in 45 minutes or something.
Sounds good.
Judicial retention all night, which
What time?
5:30.
Your excuse if you have to be.
Oh, we got a vote tonight.
Oh, God. We have a joint meeting we have a joint session next
We
week.
bumped it for the week after.
It's the 26th.
I think it's the Wednesday.
Fifth. So let's go out with you too. We'll be back here